I will be discussing the subject of istislah or maslahah today, and we'll start with the meaning and definition of maslahah, textual proofs in support of it, the varieties of maslahah, and conditions it must fulfill in order to be a valid basis of judgment in legislation. Some differences among the mazahib about maslahah, also differences between istihsan, maslahah in qiyas. I begin now with just to emphasize the importance of this doctrine. It is one of the most widely quoted in contemporary legislative discourse, and it has relevance that is quite significant, quite obvious to our contemporary concerns. Literally, maslahah means benefit or interest, considerations of public interest. It is also referred to as istislah in maslahah, but we will focus on one variety of maslahah, which is maslahah mursala, and that is unregulated maslahah. Sometimes it is also referred to as maslahah mutlaqa. That also means that it is absolute in the sense that the text in ijma has no guidance about it. It is unregulated, and it is this variety of maslahah that is important to our discussion. And it is defined as a consideration that secures a benefit or that it prevents a harm and evil, and it is appropriate with the objectives of the lawgiver. This is the definition generally of maslahah, and it is often associated with the protection of the essential values, as I will be later discussing the 5 essential values, and that take cardinal significance in the discussion of maslahah. More technically, it is a consideration that is or an attribute that is appropriate and harmonious with the objectives of the lawgiver. It secures a benefit or it prevents harm, and the Sharia has not regulated it in the textual sources of the Quran and Sunnah. The companions have acted widely on maslahah following the demise of the Prophet. They decided to compile the Quran and to collect it into one volume. They decided also to issue currency and to establish prisons and a number of other decisions on which there were no textual authority in the higher sources. But they considered this to be for the benefit of society. There is general agreement that maslahah does not apply to matters of worship, to ibadat, and also to muqaddarat that are specifically regulated in the Quran and Sunnah or ijma. For example, the specific shares in inheritance that are assigned to close relatives in the Quran, and of course the subject of ibadat, because we do not necessarily know the reason in justification for those. It is not just maslahah, but any variety of ijtihad, qiyas and other varieties also do not apply to ibadat and muqaddarat. But when it comes to civil transaction, muamalat, and politics, in government affairs, maslahah is fairly openly applied, and it is the principal zone of application for maslahah. The considerations of public interest or maslahah that we are discussing are basically unlimited. The means which realize benefit or those which prevent a harm or cannot be either predicted nor actually enumerated. And they are circumstantial. As and when the opportunity arises, it becomes the task of the mujtahid, jurist, the head of state, to secure the benefit of the people in all possible legitimate ways that they can see the opportunity for such. And if they neglect to secure it, then they would have neglected what is their responsibility and their duty. The ulama have quoted a large number of passages from the Quran and also hadith in support of maslahah. One that is quoted is the reference in the Quran, Surah 21, verse 107, that assigns the mission of the Prophet as a mercy for the world. The Quran also refers to itself in another passage, Surah 10, ayah 75. It is a healing for the ailment, the spiritual ailments in the hearts. It is guidance and mercy for the believers. Again, guidance, mercy comes up. And maslahah is connected also with the idea of prevention of hardship. Raf al-haraj, which is referred to in the Quran in several places. What is for the benefit of the people and prevents them against harm. Also, this prevents what is hardship and difficult for the people. It is categorized parallel with that. And there are also passages in the hadith. One that is widely quoted is La dwarara wa la durara fil Islam. Harm may not be inflicted nor reciprocated. And this is considered to be very broad in its application and encapsulates almost the whole range of the application of maslahah. In another hadith, it is reported that the Prophet did not consider taking a decision on which there was no textual injunction, but to decide on what is easier and convenient. Then another hadith, al-Muslimuna ala shurutihim, that Muslims are bound by their stipulations unless it is one that turns the halal into haram or vice versa. Therefore, people are free to incur commitments, to sign contracts, to initiate regulations, legislation even, if it would secure benefit for society and prevent what is difficult and hardship. There is even yet another hadith that Allah loves it, that people fulfill His commands, that follow His commands, and also to act on what the concessions that He has granted. So there are two aspects to this hadith. One is to follow what is a definitive injunction, and the other also to act upon the concessions. It is therefore no virtue for people to do what is not required of them, or if they have been given a concession during the month of Ramadan for a traveler not to fast. It's not a virtue to fast just because you think that it would be. It is better if you are given out of the grace and generosity of Allah some concession to take advantage of that. And that also means that maslahah sometimes relaxes the rigor of some of the rules of Sharia, and we are entitled to take advantage of it. One of the prominent Hanbali jurist, Najmuddin al-Tufi, wrote a commentary, a book, Al-MASLAHAH al-Mursala, which is a commentary on this hadith, and that harm may not be inflicted nor reciprocated. Equating this says that this is a clear nas on maslahah. And I will have a little more to say on this Najmuddin al-Tufi's theory of maslahah. When we talk of maslahah, basically, historically, we speak of the period of the companions, because the Prophet acted on maslahah naturally in many ways. But when he acted on something, it also became the sunnah that commands higher authority. Maslahah really takes its origin from the precedent of the companions, and on many occasions we know, for example, that the second Caliph Omar did not implement the hudud during the year of the famine because of this, what he thought was for the maslahah of the people. There was an incident, a murder in the Yemen during the time of Umar. Several people had colluded on the murder of one person, and he was faced with applying this verse of the Quran on the subject of qisas, or just retaliation. But the Quran says an-nafsu bin-nafs, life for life, meaning one life for one life. But he deliberated over that and came up with the understanding that people's life will not be secure unless all the aggressors are put to punishment. And he decided, even the whole, exaggerated, if all the people of Sana'a had colluded to murder this one person, I would take them all accountable. And he validated executing several persons for the murder of one. From the third Caliph, Osman, he also entitled to inheritance a woman whose husband had divorced her right on his death illness. And he did not accept that. He entitled her from his inheritance. The fourth Caliph, Ali, also passed judgment that it is for the maslahah of the people, and that the Amin, or the one who is responsible to take care of something that is placed under their custody, to become responsible for the damage and loss. If you put some material with a tailor, he is Amin, or a trustee. A trustee is not responsible for loss. But in this case, he decided, no, transactions in the marketplace, people's interest will require that they are held accountable for any loss or damage to such property. And then, of course, the mazahib have decided to punish, the Hanbali mazhab, to punish an ignorant physician who is not qualified but practice medicine. The Maliki school have also validated preventive detention, although the person who is detained is not known to have committed any offense, but it is for the maslahah of society. And when the maslahah is acted upon by the head of state and the ulul amr, it becomes it comes close to what is called siyasa shar'iyya, sharia-oriented policy. And a prominent jurist, Ibn Qayyim al-Jawziyya, has characterized siyasa shar'iyya as consists of all measures that bring people closer to benefit and removes them further from corruption and harm. Imam Malik, who is a strong advocate of maslahah, has given 3 points in support of it, saying that the Sahaba, the companions of the Prophet, have validated maslahah as a basis of judgment in legislation. And secondly, if there is in the Quran, in the nusus, in the textual injunctions, something that is in the genus, in category, that is comes close to what is determined in the text, then it becomes our duty to uphold that maslahah. The Sharia has penalized, for example, theft. And if anything, other misappropriation of property of all variety, we must punish it. It is for the benefit of society. And thirdly, that neglecting what is beneficial for the people usually amounts to hardship, and hardship must be prevented. The varieties of maslahah. Maslahah is from the viewpoint of the scope of their application. It is divided into 3 types. The essential masalih, known as daruriyat, that is I referred to earlier on. The essential masalih are those on which the normal order of society depends. Collapse of these essentials means collapse of normal order in society. And the ulama have mentioned 5 essential interests, that is protection of religion, life, property, family, and family and descent and dignity. These are the essential masalih, the daruriyat. Each of these is a broad and comprehensive category in its own right. When we say the Sharia protects life, it's not just to punish the loss of life by way of just retaliation, but also to enable the individual to lead an honorable living, the right to work, the right to sustenance, basic fundamental rights and liberties. They also fall under the same category of protection of life. Next is hajiyat, complementary benefits, which are complementary in the sense that they supplement the essential masalih. And they are defined as benefits which are important, but the life of society and people do not depend on it. Their collapse may lead to some hardship, but not a total collapse. For example, the Sharia grants certain concessions during the month of Ramadan, or for someone who is ill or invalid, unable to perform the prayer in the regular way. There are a series of concessions granted. Taking advantage of it is in the nature of hajiyat, complementary interests. Similarly, certain transactions have been validated by Sharia on grounds of maslahah. The forward sale of salam, for example, or the manufacturing order of istisna. In both of these, there is some abnormality, as the subject matter of sale is not present in either of these. But they have been validated simply because this is for the interest of the people. Then the third category is tahsiniyat, that which is desirable, or embellishments, sometimes known as kamaliyat. For example, purity, cleanliness, beautification of the person, one's clothes in one environment, providing services that are beyond the level of the essentials, improving the health services, avoidance of extravagance and so on. These are tahsiniyat, and this is a very broad category that can apply to the other two categories, the daruriyat. You can perhaps apply the punishment or, for example, fulfill other masalih. Do it in a perfect way or do it in a just, to fulfill a certain requirement. There is a difference. Al-Shatibi, who is the chief advocate of masalih, he says that maslahah is always relative. There is no absolute maslahah. Even the masalih that we know, some hardship, some corruption may be entailed, but so we look at the predominant aspect of the masalih. They are known to be circumstantial and also relative. The second classification of maslahah I look at briefly is also in three varieties. Accredited benefits or masalih mu'tabara. These are masalih on which there is clear authority in the textual sources or ijma. We are not concerned with that because there is authority on that. This is known as maslaha mu'tabara, accredited maslaha. Maslaha mursala, that is the focus of our discussion, is unregulated maslaha on which that higher authority are totally silent. And then between follows another category of maslaha malgha, that is vitiated maslaha, which is not a maslaha, but for want of a better expression, these are considerations which are not appropriate and harmonious with the objective of the lawgiver. They are not in the nature of maslahah. For example, practicing gambling or riba just because it becomes very common. This would not qualify. Maslahah, unregulated maslahah, actually starts after the lifetime of the Prophet, and when revelation, divine revelation, came to an end. And we have given many examples of it in modern times. For example, registration of marriage. The proof of a marriage as a contract is in Sharia, in the fiqh, there are many ways of proof, which is witnesses, documentary evidence, and other varieties of proof, but we only select one formal variety of legislation in order to prevent unwarranted claims over inheritance and over relationships. Discuss the conditions of maslahah. What conditions must it fulfill in order to qualify as a valid basis of judgment? Maslahah must fulfill three basic conditions. There are two additional conditions Imam Malik has proposed, but the three basic conditions, one is that the maslahah must be haqiqiyya. It is genuine, as opposed to specious or plausible maslahah, which is or maslahah wahmiyya, based on speculation and partisan judgment. It is not genuine, and genuine maslahah is often tied up with the protection of these five essential values we earlier mentioned. Then another good way that I have suggested to identify a maslahah is genuine is through consultation and collective decision making. The second condition of maslahah is that it must be kulliya. that it is inclusive and comprehensive, not partisan. That a benefit that is relevant to widest number of people and not to a particular class or clan or the ruling class, so to speak. We have often seen examples in history, self-styled individual make decisions, introduced even legislation in the name of maslahah, and at bottom you find that there is partisan interest involved. That would not qualify. And the third condition of maslahah is that it is not in conflict with the rulings of the text or ijma. Should there be a conflict, a direct conflict between what you call maslahah and the textual rulings in ijma, it would disqualify. Imam Malik has introduced two additional conditions, and that is that the maslahah must be rational and reasonable, that we can understand it. And the second, that it should prevent hardship and not to introduce additional hardship, so to speak. You can imagine nowadays, these insurance regulations and so on, they become so detailed, they become burdensome on people too. So that perhaps was relevant as a requirement. I will now briefly discuss Najmuddin al-Tufi's theory of maslahah. He wrote a book in the 8th century Hijrah, 14th century scholar, who take a rather unusual stand on maslahah. He wrote a book, Al-Masalih al-Mursala, and it is a commentary on this one hadith, La darara wa la durar, harm may not be inflicted nor reciprocated. And he said that is a clear text on maslahah. We notice that the jumhur, the majority of the ulama, will not apply maslahah when there is a clear text on a particular subject. But Najmuddin al-Tufi says that maslahah applies with or without the presence of a text. And when there is a text that is not in conformity with what is beneficial and for the maslahah of the people, then this particular nas will take priority. That in that case, it is not a question of conflict between one text and another text, but it is a question of explanation, bayan, and specification or making exception. Therefore, we try to compromise the two texts. In the event one of them will present an obstacle in the way of what is considered maslahah. He also agrees with the majority that maslahah does not apply to ibadat, to matters of worship and specific assignments of the text, but outside this sphere, maslahah is authoritative, and that it takes precedence over other proofs of Sharia. And this is where he departs from the majority position, especially in mu'amalat, in political affairs, in matters of management of temporal affairs of the community. Maslahah is the goal in purpose. And these other proofs are like the means of realization of what is maslahah. And he has some detail to say about how to attempt reconciliation between this nas and another particular text that may come in the way of maslahah. Now I move on to drawing a distinction between maslahah, qiyas and istihsan. All of these are rational doctrines, and therefore this is the common point between them, and there is no clear text in the higher sources to say that these are decisive proofs. They are all, in other words, probabilities. That is a point of in common between these two. But there is, of course, a difference between qiyas and maslahah, in the sense that analogy is tied up to the clear text. There is a ruling in the text, and you find the rationale and extend that to a similar case. It is a fairly confined approach in application. You don't have total flexibility to move around. But maslahah is open, and it is not limited in that sense. The same about istihsan or juristic preference. One variety of istihsan is also tied up to qiyas. That is, when there is an analogy or ruling of qiyas, and when it is applied, it leads to some kind of rigidity, then you refer to find a substitute for that through the application of istihsan. Once again, istihsan is tied up to qiyas into certain specific applications, but maslahah again is not confined to those. When there is an issue on which there is no clear ruling in the scripture, then the mujtahid in the alim takes recourse first to the sources. There is a clear guidance, or that there is some indication. It is a case either for qiyas or finding an effective cause or rationale. Following that, we apply maslahah. Maslahah is something that is very distinctive, because it encapsulates the essence of Sharia. The Sharia from beginning to end is to bring benefit and to secure the welfare of the people. Now there is a certain argument against maslahah. Maslahah is because it is subject to value judgment, and it is circumstantial and relative, as we have already said. Many ulama have taken rather a skeptical approach to the validity of maslahah as a source of law. The Zawahiri school, for example, do not accept maslahah as a source. Some Shafis, like Saifuddin al-Amidi of 7th century Hijrah, and a Maliki jurist Ibn al-Hajib, they have taken the view that maslahah is acceptable in principle, but they specify and stipulate it to an extent as if to say that maslahah is only valid if there is another clear text to support it. If that be the case, then actually maslahah loses much of its the kind of proof that we have discussed. Maslahah will lose much of its validity. This viewpoint is based on the concern that people, rulers and governors often propose certain things in the names of maslahah, and they promote other interests, that because of this circumstantial nature, maslahah may be something that may cause disparity in differentiation in the ahkam of Sharia, such that would be undesirable. And they even quote a verse of the Quran in Surah 75, verse 36. Does man think that he has been left without guidance? أَيَحْسَبُ الْإِنسَانُ أَنْ يَتْرُكَ سُدًى. And therefore they maintain that the Sharia is comprehensive, is self-contained, and it takes care of all the masalih in benefit. In the event where the Sharia is silent over a matter, it is a sure indication that that is not maslah for the maslahah of society. The Hanafis and Shafis have taken a slightly more open approach to the validity of maslahah, in the sense that the Sharia, yes, it is comprehensive, but it provides either explicitly regulates certain matters in that order, or that it provides indications, and we find and detect the rationale of the certain ruling, or we look towards the maqasid in the objectives of certain rulings, and if we then detect that there is a linkage, maslahah is validated and made a basis of judgment. The approach that the Hanafis and Shafis take to maslahah comes close to qiyas, that there is some indication, and we do not really take an open approach to maslahah if we follow the Hanafi and Shafi approach. Al-Ghazali, a Shafi jurist, he ties, as we said, maslahah to the 5 essential values or daruriyat. But the Maliki and the Hanbali school, who are the advocates of maslahah and the strongest supporters, they take an open approach, and they say that maslahah mursala or unregulated maslahah need to qualify certain conditions, and those conditions are very clear, and once they fulfill those conditions, then they qualify as maslahah, and there is no need to impose additional conditions so as to restrict further the concept and application of maslahah as a source of the Sharia. And the Hanbalis and Malikis have actually made many fatwas and decisions. The Hanbali, for example, validate death punishment for one who, for a spy during time of conflict that conducts espionage for the enemy on the basis of maslahah. He may be executed. The Maliki school, Imam Malik has validated giving bay'ah or pledge of allegiance to the mafdul, who is the lesser qualified for leadership. If conditions of society would require such that we select imam that is not the best qualified, but that the conditions of society would dictate such that we may do so. The bay'at al-mafdul is validated. In principle, it must be the best qualified. And then also, if the Baytul Mal, the public treasury, runs out of resources and funds, and there are needs for maintenance of essential services, judicial services, and so on, Imam Malik validates the imposition of additional taxes on the wealthy. And also that he has passed a fatwa that if a person does not find a lawful occupation in work, supposing living in a non-Muslim environment, is he allowed to take up a work that is unlawful and haram? And he issues a fatwa that yes, he may take it up to the extent that may fulfill his essential needs, but not beyond that. To limit the application and the scope of such a comprehensive doctrine as maslahah in ways that some of the ulama have suggested, maybe we do need to be careful not to speak so openly of maslahah, to apply the conditions that are necessary. But otherwise, since it is, broadly speaking, what the Sharia actually desires to secure the welfare of society and people, then we need not to limit maslahah and be too restrictive about it.